साथ दिया आपको। ये हम रेफर कर रहे हैं इसमें 2008 सुप्रीम कोर्ट 23 हाँ 2000 एससीसी हमारे पास नहीं है, पार्टी ने दिस इज क्या ये पार्टी नाम है धर्मपाल and others versus UP State Road Transport Corporation. In this case, your lordship, paragraph 14 में कहीं SCC का SCC paragraph 14 में may I read out for your lordship's convenience?
Yes.
Because my lord is going to therefore.
Yes.
Para 13, it starts from para 13. However, the 18,005 in Tamil Nadu State Road Transport Rajya Priya reported in 2005.
Haryana. Dharampal versus
UP State Road Transport Corporation. Paragraph 14 is absolutely clear. What would be the rate of interest? As per the bank deposit savings bank, not the lending rate. That is the clarification made by the Honorable Supreme Court in this part. So therefore, subject to correction by my learned friend and other persons, the rate of interest, the deposits in the year 2018, it was maximum 6.18.
Date of accident.
No, date of grant. The date is from the date of grant. The crux is for the date of grant. No, unless and until, I am coming to that. Unless and until, I am coming to that. Unless and until the liability is determined. Unless and until the liability is determined, how can one presume that it is payable? So therefore, it will be taken from the date of grant of the rate of interest. In that case also, that issues also there are certain judgments, your lordship. But are not armed with that one, but there are also there judgments. But so far, Dharampal is seen that in that case, it would be from, yes, the rate of interest would be as per paragraph 14 would be the bank deposits rate, not the lending rate. So if the interest tax is also applied, then in that case it will not be 9%. If the interest tax or this provision of CPC is also applied.
Date of filing of the application? What was the date of filing of the application?
The date of filing I cannot say, but it was in 2014. It was 14.
What was the rate in the year 14?
Well, I am not aware of that. I am not aware of that. But my submission would be it is from the date of grant, not from the date. Suppose if the interest is the date of filing is taken into consideration, then if the claimant acts leisurely, does not proceed with the matter, then whether the adversary other party can be held liable to pay the interest for his own wrong. In that case, the entire thing is to be seen. When I appeared, what was the date on which he closed the evidence, how he proceeded in the matter. Therefore, in some other judgment, your lordship, I am not having this, that the date is from the date of grant. I will give the citation tomorrow if my lord will permit. It would be the date.
You are relying on paragraph
14 of this judgment, SCC. Well, yeah. I do not know what is the paragraph in the
starting line.
Starting line in the backdrop.
In the backdrop.
Yes. In the backdrop, from the date of passing of the award.
But it's okay. Further tomorrow. Tomorrow. No, tomorrow.
Tomorrow?
Friday. Next Thursday.
Thursday.
Next Thursday.
Next Thursday or this coming Thursday?
Coming Thursday.
Coming Thursday, okay. And for the next case for hearing,
Yes.
in which I had concluded my argument,
Now this is which case? This one is?
this one is the 34, item 34,
This was an admission matter.
admission matter, the hearing matter, that is
Wait,
39.
what are we wait, the other admission matters? Yes.
Other matters under the heading for order, serial number 21, serial number 22. Civil division 24 or 20, is civil division 25 or 20.
May I please, my lord?
Just.
So they will confirmation of delay by application can ask the project. Delay confirmation.
Yes.
इस वाले को इसको उपस्थित कराने की ये वाला फर्स्ट जो फर्दर थर्सडे को हुआ फर्स्ट कितना
Come to me.
Yes.
May I please, my lord?
Yes.
I had the privilege of watching the last day's proceedings, my lord, or recording of this case, my lords. So I am before you, my lords, my lords. I try to assist my lords on the issues.
Tell me one thing. It was argued that the appeal is barred. Which provision bars that we?
Section 13, my lords. Section 13 of the Act.
Where is
Says-
Mr. Krishna Murari? Where is Mr. Krishna Murari?
My lord, may I place some other provision before that, if your lordship permits me? My lord, this Commercial Courts Act.
Yes, just.
My lord.
There. Yes. Yes.
Would my lords be kind enough to look at section 12, my lords?
Yes.
Subsection 3 of section 12.
Yes. 3. CBC and CBC. CBC. This is only the amendments.
Commercial Court Act.
This is only the amendments.
My lord, it must be at the beginning, I believe.
I left the act in my chamber.
My lord, I can just supply the copy of that particular provision, my lord,
Yes.
because that was not amended any time.
कोर्ट मास्टर प्लीज जरा कोर्ट को दे देंगे
Because that is a very important provision, my lords, according to me, because what was falling in my lord's mind,
Section.
section 12,
12.
subclause 3, my lords, subsection 3.
Yes.
No appeal or civil revision. Application under section 115 of the Code of CPC, as the case may be, shall lie from an order of commercial division or commercial court finding that it has jurisdiction to hear a commercial dispute under this act.
No.
So, my lords, what happens is,
This is written. No appeal or civil division application under section. This petition is from an order of commercial division.
so the legislature has specifically provided that no appeal or revision, both the things, would not lie against this specific order. So they have not provided in the same manner with respect to revisions, not maintainable. Because section 115 has remained untouched even after the coming into force of this act.
No. You're referring to section 12(3).
Yes, my lords.
So, your contention is what I could get, that if the intention of the legislature was to complete total bath of similar type of
Provision should have been
should have been
made.
made in section 8.
Yes. Because, my lords, austere of jurisdiction of a high court cannot be presumed. There has to be a specific provision which says in so many words, as it has been said in this provision, no appeal or revision. So they could have provided in that also. And section 8 is only with respect to interlocutory orders. What are those interlocutory orders, my lords?
I'm just asking you one question.
Yes, my lords.
Section 13 is the appeal.
Appeal, my lords. Appeal from decrees of commercial courts and commercial divisions.
Degrees, a person agreed by the judgment or order of a commercial.
Yes.
Now, what commercial court decides? What is the jurisdiction of
And my lords, with respect to that, would my lords kindly see the proviso to subsection 1? Because what kind of appeals are maintainable?
No, we'll see to it later.
Yes, ma'am.
Now, what type of disputes will go before the commercial? It's not
My
only
lord-
arbitration. There will be other dispute which will go to the commercial court.
My lord, yes, there are number of matters which have been listed.
What matters? My question is, what matter will go to the commercial court? Mr. Krishnamoorthy, you can also assess this one because these questions.
My lord, section 2, subsection 3, C.
Section 6.
The commercial court shall have jurisdiction to try all suits, applications relating to a commercial dispute of a specified matter.
That's why, my lord, I was referring to
Suppose-
section 2,
Section 2.
C,
Yes,
1C.
yes,
What is a commercial dispute?
yes,
Commercial dispute means a dispute arising out of 1. Ordinary transaction of merchants, bankers, financiers, and traders, etc., etc. Then 2. Export, import of merchandise, etc. 3, 4,
Now-
5,
now-
all these.
Now, I put a question. Suppose there's a dispute, mercantile dispute between two parties.
Yes, my lords.
He files, one A party files a money claim.
Yes, my lords.
Before it will be the commercial court.
If the specified amount is above the amount provided
Suppose
for.
the amount provided.
Yes, yes, yes.
It will be for the.
Yes.
We take it that
Yes,
it is
yes,
a
yes,
specified
yes, yes,
amount.
yes, yes. Much more.
It will be for the commercial court.
Yes, my lords.
It will be a money suit.
It will be a money suit.
It will be a decree.
There would be a
Why
decree.
Once a decree is passed, what will be the remedy?
The execution has to be continued.
No, forget about execution. If a party is agreed, what will you do?
File an appeal before the
Under section?
commercial division under section 13. Whatever appeals are allowed.
That means, you say as per the proviso, that means under section 13, a 96 appeal under CPC is barred.
Yes.
CPC 96 is barred.
Because appeals are provided specifically here.
I'm
So
asking-
any other, yes, my lords.
I'm asking you.
Yes, yes.
That
Any
means-
other,
That means against a judgment and a decree. If a party is agreed, what is the remedy before?
the remedy is only provided under Commercial Courts Act section 13 itself.
So what will be
So
the
it will be limited to that.
So limited to that means he will not file an appeal under section 96.
No, he will file an appeal under section 13.
Is 96 bar? Has the right of 96 been taken away?
My lords will kindly see section 13, what it says.
What is it? See?
Appeals from decrees.
Yes.
So once a decree is passed, it is
Yes.
a decree of a
Yes.
commercial court
Yes.
or a commercial division, that is of the
Yes.
High Court.
Yes.
Any person aggrieved by the judgment or order of a commercial court below the level of a district judge may appeal to the commercial appellate court within a period of so and so. Any person aggrieved by the judgment or order of a commercial court at the level of a district judge exercising original civil jurisdiction or, as the case may be, commercial division of the High Court may appeal to the commercial appellate division of the High Court within a period of so and so, provided that an appeal shall lie from such orders passed by a commercial division or a commercial
Such
court.
orders, not degrees.
No, such orders from passed by commercial division or a commercial court that are specifically enumerated under Order 43 of the CPC as amended by this Act.
As amended by this act.
Yes,
As amended.
by this Act.
Yes.
That is, amendment is by schedule, which
Yes.
provides what are the amendments.
Yes.
And Section 37 of the Arbitration and Conciliation
So
Act.
96 has not been amended. by this
96
act.
has not been amended, but specific provision has been made against which orders or the judgments an appeal would
That
lie.
means as per you, in a simple money suit, if a degree is passed, section 96 of the CPC is barred.
Yes, because there is a specific provision under which you have to go, because the suit is
Now,
entertained under the
my
Commercial Courts Act.
second question.
Yes, my lords.
Any person aggrieved by the judgment or order, read money.
Yes, my lords.
Any person aggrieved by the judgment or order of a commercial court at the level of a district judge, exercising original civil jurisdiction or, as the case may be, commercial division of a high court, may appeal to the commercial appellate division of the high court within a period of 12 months. And before that, any person aggrieved by the judgment or order of a commercial court below the level of a district judge may appeal to the commercial appellate court within a period of 60 days from the date of the judgment of the court.
This is by way of an amendment, my lords.
Suppose
2018 amendment.
Yes. We have 2000. We'll
Yes,
see both
yes,
like this. Suppose civil judge senior division, which is designated as a commercial court, passes a judgment, it will be challenged back.
It will be challenged before the Commercial Appellate Court. Because civil judge senior division, if he is below the rank of a district judge, then the appeal will lie to the Commercial Appellate Court.
Now, if he passes a degree, if say 96 is barred,
Because specific provision has been
where
made
will he
here.
go? Where will he go?
But
What will he file?
we will file an appeal under Section 13.
Before whom?
Before the courts mentioned here, my
Under
lords.
section 13.
Yes, my lords. Before two, either Commercial Appellate Court, if it is by a judge below the level of a district judge, and to the Commercial Appellate Division of the High Court, if it is before the district judge who is exercising original civil jurisdiction. Earlier, my lords, may I just submit, earlier, prior to this amendment of 18, it was only the Commercial Appellate Division, Commercial Appellate Division before the High Court. But subsequently, when the amount of specified amount was reduced from 1 crore to 3 lakhs and above, then this amendment has been brought. Because, my lords, 3 lakhs is a very small amount comparatively.
The district judges were given the power, the principal
Yes.
district judges were given the power of
So,
the commercial courts.
yes, my lord. So the courts which were below the level of the district judge were also to function as commercial courts, and an appeal would lie.
Now, there's a difference between judgment, see, provided that an appeal shall lie from such orders, provided that an appeal shall lie from such orders passed by a commercial division of a commercial court that is specifically enumerated under order 43. Come to order 43.
Yes, my lords. So, my lords will see one thing. Here, judgment or order. When it comes to judgment, it stops there. But when it comes to orders, then it is specified which orders.
Yes, specify which order.
Which orders?
Yes.
So let us.
That means if it is a judgment
Then straightway, you have a right of appeal
under 96.
under Section 13, 1 and 1A. But when it is an order, then it is to be governed by the proviso. Which orders? Which orders can be challenged in appeal under 13?
What are judgments? What is a judgment?
My lord, let
What
me.
is the judgment?
Yes, my lord. The judgment will be what is provided in the CPC, because, my lord, this is a creature of CPC. The commercial courts are a nomenclature for commercial disputes.
It's a forum.
It's a forum.
It's a forum.
It's a forum with the, it's a civil forum,
It's a civil forum.
but separately created for the purposes which are provided in the Act: early disposal of cases, international ramifications, and all those things, my lords, have been taken. The statement of objects and reasons are mentioned. So for that reason, but otherwise, the civil procedure code applies to the commercial courts, subject only to the amendments which have been made by the schedule.
Come to order 43.
Yes, my lords. Appeals from orders. My lords, that's a different video.
Order 43 is appeals from.
Yes. An appeal shall lie from the following orders.
104.
Yes.
Come to 104.
And namely, and yes, and namely they have said what would be there.
Part 7 of the CBC deals with appeals from original decrees. 104 is order from which,
Orders from which appeal lies.
that means 96 is something different.
Yes, 96 is totally different.
96 is totally different.
Totally different. Because
So,
the power of 96 has been given under section 13.
so just one thing. Order 43.
Yes.
This proviso, which says, provided that an appeal shall lie from such order passed by a commercial division of order, are specifically enumerated under order 43. That means it has to be read with section 104 also.
Yes, yes, yes. Because 43, when we look at 43, then it
Yes,
talks about
104
104.
also.
104. And then,
So,
and also section 37 of the Arbitration and
that is
Conciliation Act.
also 37. 37. So, an order which is covered under 104. 104.
Yes. 104 or order
Yes.
43.
No. Section 104 of the CBC.
Yes, madam, I am looking at
An
both.
appeal shall lie from the following orders. Save
And save as otherwise expressly provided in the body of this court or by any law for the time being
and
force
no other orders.
from no other orders.
And from no other
No other orders.
That means only these
Only these
orders.
specific orders which have been provided for in 104 or order 43.
No. See, order 43 is
It is a detailed thing, my lord. It is detailed.
Order 43 is appeal shall lie from the following orders under the provision of 104.
Namely, because here, my lord, they have given details.
They have given the details.
If your lordship will see this, from clause A to F have been deleted in 104. Then we start from FF to
See,
this.
why order 43 is there? Order 43 is there because of 104I. Order 43 is there just because 104I.
Yes, yes.
Because 104I says any order made under rules from which an appeal is expressly allowed by the
Rules. Yes, yes.
So this is
yes,
the rule.
yes, yes.
So it should be under 104 and
I.
order 43. Order
Yes,
43.
yes, yes.
So because if a suit between the parties is a money suit and a degree is passed which is appealable under section 96, then automatically the degree will be appealed under 96, not under section 104.
Then it is a judgment. Then section
The
13.
judgment and degree,
Then, my lords, there are two parts in section 13.
yes,
Because what is specifically provided in 13 would take the appeal under section 96 also.
yes,
Because it has been specifically provided here, so this will you presume that 96 provision has been incorporated here in this manner. to the extent what is provided here. So that has to be read in that manner.
What are appeals? What appeals can be filed under section 96?
That's the first appeal.
Commercial code doesn't say which appeal will file, which can be filed under which provision. Commercial Code Acts doesn't say, it only says about order 43.
Yes, yes. My lord, what happens
96?
by reference there, by
What about 96? What
appeal
is-
from
what
original
is-
decree. Appeal from original decree. 96 is appeal from original decree.
Original decree only.
Yes.
What is the nature of this order which you are challenging?
It's an order passed in an execution petition whereby the award passed by the MSME Council has been held to be a nullity,
Okay.
and hence my execution stands dismissed.
Your execution stood dismissed.
Yes, because once you say that it is not enforceable because it is a nullity, then my execution is dismissed. I have no other remedy. It's a final order. And if my lords please, my lord, I have two judgments to place with respect to this section 8. What are the orders which are covered? And then with respect to whether at 227 will lie or 115 will lie, whether it will be heard by a division bench or a single judge bench of the High Court. I'll just place those two judgments, my lords. Maybe the things will be better, more clearer, my lords.
This is the Delhi High Court, which
Delhi High
relies
Court.
upon the Honorable Supreme Court's judgment.
Yes, my lord, the Khimji judgment and many other judgments. My lord, first
Both judgments I have also crossed. I have also drawn it.
my lord, yesterday only I could lay hands on them, and today morning I got them printed and I have gone through them.
Yes.
I praise them, my lords. My lords, may I place the single judge judgment, that is with regard to what section 8. My lords had that Span Healthcare Private Limited.
Yes.
May I place that, my lords? It's a single judge judgment, my lords. Present revision petition, my friend.
Yes.
Present revision petition has been filed by the petitioner under section 115 of the CPC, assailing the order dated 12/2 passed by the trial court in CS commercial, that is a commercial court, my lords, in so and so. The trial court by impugned order has granted unconditional leave to defend to the defendant in the suit. Petitioner herein is the plaintiff in the suit and the respondent is the sole defendant. So the petitioner was aggrieved by the order granting leave to appeal to the defendant, unconditional leave to appeal. So that was the order under challenge before this honorable court, before the honorable High Court. At the outset, learned counsel for the respondent raised objection to the maintainability of the present revision petition on the grounds that the order impugned herein is an interlocutory order and a revision petition is barred under section 8 of the Commercial Courts Act. My lords have seen that provision many times. My lords, may I read that provision, section 8, if your lords want? Okay, my lords, let me continue with this. Barred under section 8 of the Commercial Courts, Commercial Divisions and Commercial Appellate Divisions of the High Courts Act 2015. Learned counsel has relied on the judgment of the Supreme Court in Babula Khinji, that's the very famous judgment, versus Jab and so on so 81.4 to contend that an order granting leave to
No,
defend.
how this judgment helps you? Because it says it's an interlocutory order, so in terms of section 8, no revision is maintainable,
No,
you go
yes.
for 227.
Yes, my lord. But in this
Because there is
case,
a judgment which says 227 is not a bar.
yes, my lord. In this judgment, they have discussed what would be an interlocutory order and whether the present order is an interlocutory order or not. And then finally,
That, what is an interlocutory order, intermediary order, and a final?
yes,
There are three types.
yes, my lord. So that all those
That is well said.
all those discussion has been made,
That is well said.
and there is a finding that the order granting leave to appeal
That could be-
was an yes. No, but they have discussed many Supreme Court judgments and other judgments here. My lord, I will just place a little bit of it. Reliance is based on the judgment of the Gujarat High Court in so and so to substantiate the argument that there is a bar under section 6 of the so and so. Albeit the court has held that repetition under 227 of the Constitution.
Madhulima has been considered or not? In this case?
And if my lords will see page 3, the issue has been framed.
Which judgment was
Single judge.
this is Spanish. In this case, Bangla Khimji has been discussed,
Yes, yes, Bangla came
and then one more judgment has been discussed. This is Shukla has been discussed.
Mr. Shukla has also discussed.
DC Supply is discussed, then Kerala High Court, then Gujarat High Court, then division bench of the Madras High Court, Magic Frames, well, all those are discussed.
University was recent 2018-11 722 has been taken care of.
LIC versus Sanjeev Builders.
When 1981 years.
Then Santi Kumar, 74 to SEC.
All the judgment has been.
Yes, most of the judgments have been considered, my lord, and then
See, these cases defines what is an interlocutory order, what is a final order, what is an
Intermediate
order,
order.
what is a judgment.
yes.
Now, we have to see whether your case falls in which category.
Yes. That's
Your case, by virtue of the order, the entire proceeding has been come to an end. So it can be said to be a final order.
final order. So the provision of section 8, that bar of revision will not apply in my case because there
Yes.
the play of CPC section 115 is fully there.
So your case is that your simple case is section, if there is a bar under section 8, it is only in respect of interlocutory order. Your order, by the order which has been passed, is a final in nature, so section 8 is
The bar doesn't apply.
Bar will not apply.
Yes.
This is your case.
Yes.
So even if an appeal is barred, revision is not.
Yes, not bar because section 12.3 specifically says
That you have shown to show the intention of the legislature.
yes, because they have
The
clearly
legislature was that he could have had that no revision is mentioned.
yes, they could have said that not interlocutory orders, but they should have no revision would be maintainable.
Now
That is
my
one.
second point is, even if it is no bar, you have a right to file a revision. Can a single judge of this type, who is not a commercial,
Yes.
can hear it?
For that, the other judgment.
Yes.
My lord, would my lords kindly see paragraph
Black diamond.
6?
Black
Yes, Black Diamond. That's a division bench judgment.
Yes, it's paragraph 6.
Paragraph 6. Exactly those questions have been posed here
Yes.
and they have answered. Came up for first before this was exercising powers under so and so when the court was counsel were asked to address on the following two questions. Whether after coming into force of the commercial code a petition at 220 of the Constitution of India lies with respect to non-appealable orders of the commercial court. If the answer to the above is in the affirmative, whether the state petition is to be considered by a single judge of this court or on a parity of the jurisdiction for
Whether
hearing
the
appeals.
state petition, whether the state petition means a petition which is under Article 227. Not under
No,
150.
both have been considered. They have said about both the things. I'll read that, my lords.
Yes.
If the answer to the above is in the affirmative, whether the said petition is to be considered by a single judge of this court or on a parity of the jurisdiction for hearing appeals before a commercial division of this court, so on. So, my lords,
Where is the finding?
my lord, a few paragraphs can I read?
Yes.
Then, my lords, 7 can be skipped. Then 9, my lords, paragraph 9.
9.
Because 7 is with respect to the another petition which was tagged
9
along.
is with revision, yes.
The question of maintainability or so on of the content with reference to the proceedings in the commercial suit before the decision arose under section 8 of the Summons Contract. That is quoted, my lords. Expressly barred the remedy of civilization application or petition. It was deemed appropriate to hear the counsels on whether by use of the word petition in the addition to the word civil division application, though with or between them, the purport of so and so was also bar the remedy of 227 petition. With respect to the proceedings in the commercial suit at the level of the district, the remedy under 227 of the Constitution and everything was similar, identical, at par with the remedy of a civil division application under section 115 of the CPC, and it was thus deemed appropriate to frame the issue question number 1 aforesaid and hear the counsel there. Similarly, it was deemed so and so, so and so. The senior counsel for respondent in so and so, in our view, has rightly condemned and none of the other counsels have controverted that the remedy under so and so, being a constitutional remedy, could not be affected by a statute framed by legislature which was itself a creature of the Constitution. Then, my lords, last few lines, 5 lines. In the wake of the said amendment, a question arose whether on the such amendment restricting, limiting, that is with regard to 115, my lords. We are reminded of so and so judgment concerned with the impact of the amendment in section 150 of the CPC brought about by the amendment of the CPC with effect on 1st July 2002. In the wake of the said amendment, a question arose whether on such amendment restricting, limiting the orders of the subordinate courts with respect to which a revision application under 115 of the CPC could be preferred to the High Court, and agreed person was completely deprived of the remedy of judicial review under Article 227. Also, it was held that it was held that curtailment of judicial jurisdiction of the High Court did not take away and could not have taken away the constitutional jurisdiction of the High Court to issue a writ of certiorari to the civil court, nor was the power of superintendence conferred so on and so on. Then, my lords, paragraph 11. Thus, question number 1, said is answered by holding that the petition that so and so is maintainable.
Para 11 the answer was the first question.
Then, this brings us to the question number 2, whether a petition under so and so with respect to the proceedings under a commercial suit at the level of the decision is to be heard by a commercial appellate division or the bench allocated in the roster to hear petitions under so and so. So, my lord, it is a prerogative of the Chief Justice by order make a roster to hear petitions
Here,
either before
here the court was dealing with 227.
227. My lords will see the 13,
115.
para 13. Para 13.
Yes.
The aforesaid question was framed because, as per the prevalent roster allocation of this court, petitions under Article 227 of the Constitution of India, as well as revision applications under Section 115 of CPC, are to be heard by a single judge of this court. Similarly, appeals against orders in a non-commercial suit at the level of district judge, as per roster allocation, are heard by a single judge of this court. However, since the Commercial Courts Act section so and so requires appeals for commercial suits at the level of district judge to be heard by the Commercial Appellate Division, need was felt to hear the counsels whether the petitions under so and so arising from commercial suits should also be heard by a division bench or by a Commercial Appellate Division, as held by the single judge of this court before which these petitions were listed. Now, paragraph 14. The senior counsel for so and so has also rightly contended that the remedy under Article 227 of the Constitution, being divorced the Commercial Court Act, would not be governed and guided by the Commercial Courts Act and would be governed by the roster allocation of this court. In the case of 115 also, my lord, there is a roster made by the Honorable Chief Justice, there is an order passed, what kind of a matter will go before a single judge, what kind of a matter will go before a division bench.
So this is a revision under section 115.
This is a revision under section 100.
Section 8 of the Commercial
Courts Act.
Then
To section 5. To be
just a minute, let him. Then,
Sorry, madam.
if it is read with section 8 of the Commercial Courts Act,
Yes, if it is read with, but there is no specific separate roster created by the Honorable Chief Justice that this matter should also go before a division bench. There has to be a specific, because only and only as per the Act, appeals have to go before a division bench. Neither 227 nor 115. That is the prerogative of the Chief Justice to pass an order.
227, see, this commercial court could have put commercial courts act.
Because my lord,
under 227.
Paragraph 13, you might not see, they are talking about both the things, 227 as well as 115, roster of the High Court. So that is the Chief Justice prerogative. If he has not passed specifically that any civil division arising out of a commercial court act has to be heard by only a division bench, then it would lie in the normal roster of the courts where a division would lie. Because, my lords, under 227 also, let me just give an example. An order, a judgment on order passed by a central administrative tribunal has to go before a division bench. Writ jurisdiction 227, superintendence, has to go before a division bench. But many other cases, they don't go before division bench. Because specifically there is some order passed. L. Chandra Kumar is there.
There is a judgment.
L. Chandra Kumar, 97 judgment,
Yes.
which says, don't come directly to the Supreme Court from the court's order, CAT's order. Go to the High Court. Let us have the privilege of looking at the views of the High Court on the judgments. But there, my lord, the reason which I feel is because the chairman of CAT is a former judge of a High Court, sitting with another member of the bench. So, for due respect, my lord, that it should be heard before a division bench. Similarly, in many other cases, many other tribunals and commissions where they are manned by a retired judge of the High Court or of the Supreme Court, sitting with along with some other member.
Mr. Counsel, your order, your award passed by senior Supreme Court judges are being dealt with by a
District Court.
senior judge, 7th Division District Court. So please,
my lord, with due respect, my lord has put something very important, my lords. What I feel, my lords, I feel, once, it is just, my lord, once a constitutional post is held, whether it is a High Court or Supreme Court, after that, there should be an end to it.
I'll not make any comment.
No, my lords, according to me, that's just a personal view.
You can make many arguments.
No, I am not making an argument, just personal view. That's what, my lord, because otherwise, my lord, going to the lowest level, you are the Chief Justice of the Supreme Court, and then going to the lowest level, your whatever.
Your award.
Goes to the lowest level.
Yes.
Civil judge, principal civil judge.
Yes. No, I understand what you want to say.
Then, my lords, I'll continue with this because there are other things which deal with CPs 115 also, my lords. Then, my lords, can we take page 9, my lords? At the bottom, lords, you can see page 9 of 18.
Yes.
Then, my lords, with respect to section 15, 115, they talk, because in this case, paragraph 16, my lords. Learned simply of the respondents must so and so argue that the remedy for defense that the court is which the suit has been instituted does not have jurisdiction to entertain so and so, so and so, so and so. Then, my lords, last couple of them. Orders of dismissal of application under so and so as well as application under so and so are revisable under so and so the CPC. If otherwise satisfy the requirements thereof of failure to exercise jurisdiction or so and so, so and so. If an application that is with regard to 115 minors.
Yes.
Made in the exercise of jurisdiction illegally or with a material. If an application under so and so is allowed and the plaintiff rejected, the resentment order is a decree under so and so and applicable under section 96. Similarly, in an application under order so and so is allowed, the same is applicable under so and so CPC. On the contrary, if the application under order 7 rule 11 is dismissed and the order is made in failure of exercise of jurisdiction or acting in exercise of jurisdiction illegally or with material irregularity, the provision to section so and so is satisfied, because had the application been allowed, the said order would have finally disposed of the suit. And similarly, the order of dismissal of application under so and so is also revisable if an outcome of the failure to exercise jurisdiction on so and so is illegally and so and so. Because if the application had been allowed, the suit have been disposed of by return of the plaintiff. We drew our attention to the senior counsel for the respondent so and so to the provision to section 115(1) and inquired whether the words would have finally disposed of the suit or other proceedings mean disposal of the suit by the court in which it was filed, even if by return of plaintiff, or the required disposal of the suit on merits. An order disposing of the suit by return of plaintiff under order so and so, those disposal of the suit as far as the court which is found to have no territorial jurisdiction to enter the suit, but leave the plaintiff entitled to sue for the same relief in the court of appropriate territorial jurisdiction. It was thus inquired whether from the use of the word finally in the provision to so and so 150, it follows that where the suit can be instituted in the court of appropriate territorial jurisdiction, it cannot be said to have been finally disposed of. The senior counsel for so and so contended that though he had not found any precedent on so and so that then minus then 20. The other counsels have not done so. Then 20. We have considered the contentions of the senior counsel for the respondent in so and so. Supreme Court in Raizada so and so held that even when a trial on merits, it is found that the court has no territorial jurisdiction, the plaintiff has to be ordered to be returned for presentation to the proper court and the suit not to be dismissed. To the same effect is the full bench judgment of so and so. Also held that for lack of territorial jurisdiction, the plaintiff has to be returned under order so and so and not rejected under so and so. The view in Allahabad so and so is also the same. It thus follows that the order impugned in CM so is of the dismissal of the application under so and so and not under so and so. As far as query with respect to the use of the word finally in provision to section 115 is concerned, we find that the Supreme Court in Sri Amarchand and others to have held that when a plaintiff is returned for presentation in the proper court and was presented in that court, the suit can be deemed to be instituted in the proper court only when the plaintiff was presented in that court, and that the suit instituted in the proper court is not in continuation of the suit filed in the court which returned the plaintiff. It was further held that the order passed by the Panipat court done in the plaintiff for presentation to the proper court was a final order and operated as res judicata, precluding the appellant from challenging its correctness in the appeal against the order of the court in which the plaintiff was subsequently presented. Therefore, we deduce that even an order returning the plaintiff for lack of jurisdiction, territorial jurisdiction, is an order finally disposing of the suit as far as that court is concerned. Once it is so, the order dismissing the application as so would satisfy the requirements of provision to section so and so, as much as if the application had been allowed, the suit would have been finally disposed of, and such an order, if made failure to exercise jurisdiction so and so, would be revisable under section 115. It thus follows that the impugned order is revisable under section 115 of the CPC. We may at this stage clarify that though the application under order so and so in the commercial suit for which so and so arises, was also filed on the ground of suit being barred by res judicata, but we have in our discussion herein above not considered the same aspect down because we had occasion to deal with an appeal against an interim order in the same suit and by judgment dated so and so negated the plea of res judicata. The counsel for so and so. Paragraph 25. Having held that the order impugned is revisable under section 115 of the CPC, we inquired from the counsel for the petitioners, therefore, how a petition under section so and so is maintainable. The counsel for the petitioners contended that the petitioner solution of the question has been filed because revision under section so and so is barred under the Commercial Courts Act. Commercial Court Acts bar only interlocutory orders. We have considered the aforesaid aspect. A petition under so and so of the Constitution is a discretionary remedy act, which discretion is ordinarily not exercised when an alternative remedy is available under the CPC. So, Surya Devi and others. Yes, and my notes over the page. It has been held that Article 227 cannot be invoked where the remedy of appeal or revision are available. Thus, behold Section 8 of the Commercial Court Act, a petition under Article 227 would not have been entertained against an order of dismissal of an application under order so and so for the reason of the statutory remedy of revision petition being available to the petitioner defendants. The exercise by the High Court of the powers jurisdiction under Article 226 is subject to well-known, well-settled rules of self-disciplinary practice. such judicial power is not to be exercised in derogation of statutory provisions. That is section 150. In so and so, it was held that it was not appropriate for the High Court to have interfered with the order in exercise of powers under so and so when the proceedings arose under the Special Act which did not provide of second appeal or revision to the High Court. That the purpose behind not providing such a remedy to the finality of the order passed by the court. Similarly, in so and so, it was held that the power of superintendence under so and so cannot be exercised in a manner ignoring or violating the specific provisions of the statute, and that the High Court, while purporting to exercise powers under so and so, to keep inferior courts and tribunals within limits of their authority, should not itself cross the limits of its authority. To the same effect is so and so, it was held that though no hurdle could be put against the exercise of constitutional powers of the High Court, it was a well-recognized principle which gained judicial recognition that the High Court should direct the party to avail himself of the statutory remedy before resorts to the constitutional remedy. The petition under so and so was held to be not owing to the availability of a remedy of appeal under CPC. In so and so, also it was held that to safeguard against a mere appellate or revisional jurisdiction being exercised in the garb of exercise of supervisory jurisdiction under so and so, the courts have devised self-imposed rules of discipline on their power. Supervisory jurisdiction may be refused to be exercised when an alternate efficacious remedy by way of appeal or revision is available to the person aggrieved. It was held that the High Court should have regard to the legislative policy formulated on experience and expressed by enactments where legislature in exercise of its wisdom has deliberately chosen certain orders and proceedings to be kept away from the exercise of appellate and revision in the hope of accelerating the conclusion of proceedings under so and so. Then 6. The reasoning therefore give rise to the question that since the remedy of revision under 115th of series, though available under the CPC against the order of dismissal of application under so and so, has been taken away under the constitution, whether the petitioner so would like. We are of the view that once the commercial courts had expressly barred the remedy of a revision application under section so and so of the CPC with respect to the suits within its ambit, the purpose thereof cannot be permitted to be defeated by opening up the gates of 227 of the constitution. The scope and ambit of the petition under 227 is much wider than the scope and ambit of the revision application under section 156 CPC. Whatever may be done in exercise of powers under so and so can also be done in exercise of powers under 227. Allowing petition under 227 to be preferred even against orders against which a revision application under section 150 would have been maintained, but for the bar under section so and so would nullify the legislative mandate of the Commercial Courts Act. Recently, in deep industries, in the context of petitions under 227 of the Constitution of India, with respect to the orders in an appeal against an order about arbitrary tribunal under section 17 of the Arbitration Act, it was held that in petitions under 226 to 227 of the Constitution against orders passed on appeals under the Arbitration Act were entertained, the entire arbitral proceeding would be derailed and would not come to fruition for many years. It was observed that though Article this 227 is a constitutional provision, it remains untouched by a non-obstant clause 5 of the Arbitration Act. But what is important to note that though petitions can be filed under 227 against judgments allowing or dismissing first appeals under the Arbitration Act, yet the High Court would be extremely circumspect in interfering with the same, taking into account the statutory policy, so that interference is restricted to orders which are patently lacking in inherent jurisdiction. Thus, though we are of the view that gates of 227 ought not to be opened with respect to orders in commercial suits at the level of the district judge against which a revision application under CPC was maintained, but which remedy has been taken away by the Commercial Court Act, but abiding by the judgments aforesaid, hold that it cannot be said to be the law that jurisdiction under 227 is completely barred. However, the said division is to be exercised very sparingly and more sparingly with respect to the orders in such suits which under the CP were revisable, and which remedy has been taken away by the subsequent decision, that is so and so, and ensuring that such exercise of jurisdiction by the High Court does not negate the legislative intent and purpose behind the Commercial Courts Act and does not come in the way of expeditious disposable of commercial suits. We thus hold that the petition and so to be maintainable with respect to so and so. However, the discretion which is in the facts and circumstances such petition is to be entertained or not, having under the roster been vested in the single judge, we leave it to the single judge to exercise such discretion. Resultantly, so and so is to be put up before the single judge. Then they talk about the other issues 3 and 4, and then my lords. Last paragraph 35, 36, 37, 35, 36. Though we have framed the aforesaid provision, but in accordance with what we have held here in our previously the decision therein falls in the domain of bench competent to hear the paragraph 35 minutes. Though we have framed the aforesaid question, but in accordance with what we have held herein above, strictly speaking, the decision thereof falls in the domain of the bench competent to hear the petition under Article 32 of the Constitution and to, in its discretion, adjudicate whether to entertain the petition or not. Then there is, however, no immediate counter agreement that against an order dismissing an application of our solution also would lie in our hands.
Yes, Mr. Murali. You said that this revision is not mentioned.
Plus, two things, Lord.
Then what is mentioned?
I simply to understand again. One, this judgment that my friend has just read. So try and see the question once again, the friend. Very carefully, Lord, I'll read it. My friend has read it so a bit faster. And these two judgments, fortunately, in the second night also I gone through and I have downloaded yours. Because I was expecting that he is coming from Delhi and he will be coming with
Yes.
So the first was the space case that my friend has placed. Because there was the law commission report that was taken care of and after this the High Court of Delhi in this Aspan healthcare case was page 4.
Mr. Murali, the provision of law is quite clear that if there is an alternative remedy, 227 is not mentioned. You are saying 227. This order is to be challenged under 227. That means show me that appeal. You said that no appeal. Both of you agree that no appeal lies.
Yes.
And you show me that no revision lies also.
First was this one paragraph I am able to place with this paragraph 12, this Aspan case.
First show me that.
This
Show me that revision is not mentioned.
plus this judgment of my case.
You also admit that he has a remedy.
He has any remedy.
He has a remedy in 227. You are saying.
Why I am saying so?
Yes, you are saying 227. First of all, you have to say why 227 because there is no other remedies. 7 except 227.
Yes.
That means section 8 is complete bar.
Complete bar.
Show me that.
Complete bar to be read with laws section 13.
Yes.
To be read with section I was placed on the last date. The section 13 minutes is in
Yes, section 13.
section 13 was. I am saying that this whole object of the act is to reduce the loss forum of litigation and reduce the time of litigation. To minimize the scope of litigation. Section 13 has been used in a very restrictive sense to restrict the scope of appeal or revision loss. Or in the whether it is a revision or the appeal loss, because once there is a relation of loss, higher court and lower court, I have no space in the judgment of this. This 2010 3 SCC case 34.
2010.
3 SCC case 34.
Yes.
Para 36, para 33 and 36 which I have placed in the last.
Para 33
3 and 36.
and 36.
As I was read that judgment in the last previous paper on loss conciliation. Then the laws American jurisprudence and the Indian jurisprudence, including the full bench of Madras High Court, have been dealt with and been said that revision is nothing but in laws one of the species of the appeal. And the test is the court to which the appeal or revision is filed and power of correction of the interrelation between the laws higher court and the lower court. Then I will again place for my consideration.
Yes, you have read.
I will give this. Now, since section 13 has been used in a very restrictive sense, was it uses the word very wide. Judgment order. Where the Kandala court judgment clause on the which they have only preferred appeal clause section 13. Against this order, they have preferred appeal clause considerably before this court, and that has been dismissed because that is on the record of
That they have withdrawn.
No, that has been withdrawn on the basis of the Kandala court judgment.
Yes.
And I filed closing of petition in closing the judgment of Kandala export judgment willots. This Kandala export is 2018-14 SCC page 715.
That I have gone through.
Here we were the laws were interpreted section 13 of this code. And there are also that came to the finding that though
That judgment was dealing with section 13 only, not section 8.
section 13 only because there was the scope of the appeal, second appeal, several.
It's only 30.
Section 30, 37, the arbitration act, etc. I went to a further consideration there. This was one of the hallmark that I was reading laws on several purposes. It also was in the context of how the provision of law will be interpreted on interpretation also, etc. How the judgment is.
That is Justice Nariman and Justice Navin Sinha.
Justice Nariman, Justice Nariman, very true. I'm guessing no question is that appropriate state laws. The gentleman laws I am doing also, I am trying to sort out the case that once a appeal is expressly guard against a particular nature of the order, that to violate a specific provision of the statute which has been promulgated by way of restrictive laws provision, that cannot be bypassed or circumvented by responding to a general remedy. Only the special remedy is part of the special act. A general remedy cannot be responded to circumvent the same laws. Or it may say so laws. The law prescribes something to be done in a particular manner, and has to be done in that only or not at all. And that I am reading along with this laws 2010 SCC page 34 that I have used now. Secondly, laws, section 8, there are lots of laws bar against division or petition against the interlocutory order. But it is not that so simple because it also goes further, including an order on issue of jurisdiction and any such challenge subject to laws of the section 18.
Yes.
It is very wide in the sense. Otherwise, these words would not have been there. The section could have stopped by simply saying like CPC. The decision will not lie against the interlocutory order as simple as it is 150 laws of the CPC. But it is not so simple. It is worded like this laws that notwithstanding anything containing any other law for the time in force, no civil division application of petition shall be entertained against any interlocutory order of the Council Court, including an order on the issue of jurisdiction and any such challenge subject to provision of section 13 shall be raised only an appeal against the decree of the Council Court. So in this circumstance, the Lordship said, no revision against if there is a interlocutory order, no revision. If it is a final order, then only section 13. This is what I understand with this laws. If it is a final order, you have to only review to section 13. Otherwise, the legislature could have given a clear picture. What kind of order against which the revision will also not. It is silent. They are against it. In that act, nowhere talks of against which provision, against which order, there will be an open remedy of revision laws. If it is really that restrictive way laws, this section 8, then the purpose of section 13 will be rendered possible. Section 13 has to have laws leading with the section 8, or section 8 has to be related with the section 13. Otherwise, every order passed by the commercial court could be leading to the High Court in the revision will say. Whatever is not done in section 13, then the purpose of section 13 will be frustrated. And all the more laws, the word in the section 13 is also wide and take note of the word. Any person agreed by the judgment or order of the Council Court below, level of decision may appeal to Commissioner of Appellate within a period of 60 days. Any person agreed by the judgment or order, both judgment and order. If it will not follow judgment, something will fall in order. If something will not follow in order, something will follow judgment. Then it will be a floodgate.
Floodgate will always be there in view of section 227, Mr. Kar.
227 laws
In
is
view of
always
227, floodgate will always be
but the scope of laws, the interference clause in 227 is very limited. Laws that is 115.
Scope, I am not on the scope. You are saying opening of floodgate.
Floodgate.
I am not saying about the result. I am saying about the entry into the High Court. It's
I am saying
not 227.
That is the extraordinary loss writ jurisdiction that is in the supervisory nature. That cannot be said because general remedy is always an extraordinary remedy.
Be it a statutory remedy or a constitutional remedy or extraordinary remedy, the remedy is there.
Remedy is
You
there.
are not shutting off the
Nobody
remedy.
can make remedy
Because the
less.
floodgate will open, it's not that floodgate is always open.
What is get to the subject laws?
Yes.
That is the extraordinary remedy laws. That is not circumscribed by any provision or any interpretation. Here laws, I am saying that section 13,
And if nothing is there, then 226 is there.
226 now was that has been also been said that
Nothing is
is
there, 226 is there. You cannot stop anyone from.
That is the saying like a Ramban.
Yes.
No, now was fallacy. The judgment that
So don't worry about floodgates.
I'm on the issue that I'm saying that that is an extraordinary constitutional jurisdiction that cannot be equated with the 115 units. 115 is general or remedial laws which actually have vis-a-vis the provision of law. And 115 are placed laws, one if possible, see 115 to be read with section 8, 115 to be read with section 8 for difference in activity.
Yes.
So I am saying that section 8 was not required as such, then everything is governed with 115. 115 is already there. There is no requirement of section 8 as such. It is what is there. Coming to questions. Division. There it was.
One. Yes.
What is the difference between 115 or section 8? The High Court may call for the record of any case which has been decided by any court subordinate to the High Court and in which no appeal lies thereto. And if such subordinate court appears to have exercised jurisdiction not vested in it by law, to have failed to exercise jurisdiction so vested, or to have acted in exercise of its jurisdiction illegally or with material irregularity, the High Court may make such order in the case as it thinks fit, provided that High Courts are not under this section 9 reverse or in order for deciding an issue in the course of suit or other proceeding, except where order, if it has been made in favor of the party applying for revision, would have finally disposed of the suit or any other proceeding. If no one talks of no interlocutory law, it is not using the word, it simply says that if it has been made in favor of the party applying for revision, would have finally disposed of the suit or other proceeding.
It is well settled against the interlocutory order, revision is not met.
Correct, therefore, so had it been so with the intention that 115
No doubt about it.
there is no doubt about it. If having the intention of the legislature laws that 115 will apply as stricto sensu as it is, then the wording of the section 8 would not have been as such, which say that subject to provision of section 13 shall be raised only in an appeal. The last most this concluding portion by which this scope of this section 8 is circumscribed clearly goes to show us that 115 is not as open as it is in the CPC for revision in this commercial code provision. Commercial code provision was clearly say that appeal, if at all the appeal is also, or if it is interlocutory order, no division, and if not interlocutory, then only appeal.
Rather, you say that it should be interpreted in this manner. Section 13 appeal. What doesn't come within section 13 to 20.
This can be
This is your argument.
So this is what
That section 13 or what doesn't come within the purview of section 13, you come into 20.
why was there reasoning was this judgment that this Sandeep Asakar 2010 SCC 34. If that is not interpreted as surplus, then purpose of section 13 will be frustrated. And take once again, I read that for lordship and just to reference the clause, paragraph 33 and 36 of that judgment, that is significance.
10.3.
Section and clause 10.3 and 634. And then, as rightly followed from my lord, the object of the commercial code that has to be taken care of.
Yes.
And
10.3. 34. Yes.
Para?
34.
plus can take place 25, paragraph 25 questions.
Paragraph 25.
Plus,
Yes.
because what is being dealt with here in after is plus said. At this stage, we may not deal with the
Madam,
decision.
may I
Paragraph 25.
if my, paragraph 17 would be important because that is the only question which has been considered by the
Well,
court.
paragraph 17 was better.
That is more important.
Very good.
The only question that arises for our consideration is whether the expression appeal used in section 7 of the Interest Act, that is payment delayed interest act, delayed payment to small scale industry act, includes an application to set aside an arbitral award filed under section 34 of the Arbitration Act 1996. And the matter of this act, Interest Act, is the interest on delayed payments to small scale and ancillary industries undertaking Act 1993, which has been repealed, and now the MSME Act has come into its place with the larger provisions.
Plus, more than that, what I am saying was, here the plus word application is there in plus under section 34. An appeal in the nature of the application was filed under section 34. And the plus upfront amount was not deposited. The objection was raised by the opposite party that since the matter arises out of the Interest Act, and though the word application is there under section 34, if it is in the nature of the appeal under section 7 of the Interest Act, therefore upfront amount of 75% has to be deposited. The argument was raised that this is an application, not an appeal. Then the lordship has exhaustively dealt what is the appeal actually means. Then was this agreement. So it has got a direct bearing upon our case. And you see, this paragraph. After this paragraph 25, on what I will tell when my friend has just pointed to paragraph 17, has already read. Then what is the appeal laws that will quoted paragraph 7 of the Interest Act? No appeal under any decree, award, or order shall be entertained by any court other authority unless the appellant in supplier has deposited with 75% of the amount in terms of decree, award, and the case may be in the manner directed by such a suit. What I am trying to point out the point was that this is also a restrictive provision. It is not that everybody will come and file the appeal without posting the 75% amount. So the legislature had the intention to minimize the scope of appeal. Therefore, this provision was there, deposit 75% amount. And it was, then I was reading those. Paragraph 19, Lordship may just I have explained those 35-75%. Then paragraph 21, according to the counsel for the appellant company, no term can have definite meaning independent of its context. The exercise of the appellate jurisdiction can take various forms. Paragraph 21 on what I am reading those. There is no reason to read appeal in a narrow sense as being an appeal under section 96 of the Code of Civil Procedure against the decree or against an order under section 4, 6104 of the Code. The learned counsel further argued the word award in section 7 cannot be ignored nor can it be rendered meaningless. Hence, an appeal within the meaning of the said section would lie from the arbitral award as well. The respondents, on the other hand, submits when a statutory provision is clear and ambiguous, the court is not empowered to read anything extraneous to the statute into it. The word of the statute shall be given effect to irrespective of the consequences. The argument was in section 34 does not talk about any amount to be deposited. Therefore, it should be read as it is. Then, which was regarded the contents of the appellant company that while interpreting the statutory provision in context and the object behind the same cannot be lost view of is no doubt correct. At the same time, the contention of the respondents that when a term appearing in the statute is clear and unambiguous, only the literal rule of interpretation will apply, must also be accepted. What then has to be seen is whether the term appeal
is one of the clear and definite meaning. If it is so, that meanings shall be given effect to, irrespective of the consequences of such construction. If on the other hand the meaning of the appeal is ambiguous, the interpretation that advances the object and purpose of the legislature shall be accepted. Before we proceed to consider the true meaning of the word appeal, we may note the contention of the learned counsel for the appellant company that no expression can have meaning independent of its context. The appellant company relied on a number of decisions in support of the proposition that the word is not a crystal, transparent and unchanged. It is the skin of the living thought and may vary greatly in color and content according to the circumstances and time in which it is used. Plus, what is the requirement of promulgating commercial code? The requirement came fair only when the laws MSME Act, Arbitration Act, CPC, etc. were not laws coming to the laws expectation of expeditious disposal, etc. There is another special act to reduce the scope of litigation and minimize the loss time of disposal. Then this section 13 was lost, and my lord was asking in the first half. Why not section 96? That is also not excluded loss in a schedule. Anybody can go to the section 96, but that is not restricted. No. Only those orders of judgment will be available which falls within the meaning of the order 43 of the CPC. That's all. So that is what in contest and control we have to appreciate loss ability. In this Gramophone Company India, Virendra Bahadur Pandey, while interpreting the term import, this court observed that the dictionary was not helpful when a word of common parlance with varied meaning is to be construed. It was held that such words have been construed in the context in which it appears. Similarly, in Central Bank of India, State of Kerala, while interpreting the term debt and security interest, this court had followed the principle as mentioned in similar view was expressed in Sana Singh while dealing with the ambit of the expression shall here, in section 235 of the Code of Criminal. At this stage, we may now deal with the decision cited by the learned counsel for the appellant in which meaning of the word appeal was an issue. Exact was the state of Gujarat versus so on which the single judge of the High Court relied on while delivering the judgment, which was set aside by the division bench of the High Court by a union order, had categorically held that term appeal cannot have a universal meaning fitting all contexts and purposes. In Nagendranath Day versus Suresh Chandra Day, their lordships of the Privy Council were concerned with the construction of Article 182, Schedule 1 of the Limitation Act 1998. The time of limitation under this provision would run from the date the final decree or order of the appellate court if there was an appeal. However, in the application purported to be an appeal filed by one Madan Mohan only, the decree holder, not judgment debtor, were main parties. Further, it was incorrectly held that no decree was drawn up and the appeal was purported to be from the order of the court below. It was contended that the application was not an appeal but a merely abortive attempt to mean appeal. It is not at all necessary. Parties were made party to it also because it did not embezzle the whole decree. 28. The court held in Nagendranath case an application by party to an appellate court asking it to set aside, and you must appreciate this paragraph 28, I am just emphasizing again because I could not have this loss. Ultimately, I have to contest over it, I know. But I am assisting the court loss only by way loss, whether what is the loss scope of interpretation of the act. An application by a party to an appellate court asking it to set aside or revise the decision, kindly appreciate the word, of a subordinate court is an appeal within the meaning in ordinary acceptation of the term, and that is no less an appeal because it is irregular or incompetent. If these two words, it is no less an appeal because it is irregular and incompetent if it is transposed in the section 115 laws. That is 115. I am paused for lots of consideration. It will straight away fall within the sweep of 115 laws. To exercise 115 laws A, B, and C. C talks of who have acted in exercise of a jurisdiction illegally or with material illegality. Now, their logic is that in Nagendranath case, what is being interpreted? Any application by party to an appellate court asking it to set aside or revise a decision of the subordinate court is an appeal within the ordinary acceptation of the term, and that is no less an appeal because it is irregular or independent. So 115, if it is read along with this clause finding, then that is outwards vis-a-vis section 13. Their lordship in this case adopted the literal meaning of the term appeal and held that it was not open for them to read into the statute any qualification as to character of the appeal or as to parties to it. In Raja Kulkarni, so a similar question was raised in the context of Industrial Dispute Act 1950, which prohibited a workman from going to the strike during the pendency of an appeal. Relying on Nagendranath, this court held it was not necessary that such pending appeals should be valid and competent appeal. This court, however, unlike the Privy Council, looked into the object of the Act. Industrial peace should also be disturbed so long the matter was pending in the Court of Appeal, irrespective of the fact whether such an appeal was competent in law. In Melaram versus Swenso, it was relied on the pertinent to issue. In this case, it was held an appeal presented out of time is an appeal in order dismissing Swenso. In Prombo Nath versus Swenso, an order dismissing an application as barred by limitation under projecting an application under Section 5 of the Limitation Act to excuse the delay in presentation was held to be one passed on appeal within the meaning of Section 109 of the Court. The senior counsel for the appellant company further argued that appeal may not necessarily always lead to the review of the impugned judgment on question of fact and law. It may be an application for the possible reversal of the impugned order or bar on the ground of illegality or improper proceeding. Hence, an application under Section 34, the Arbitration Act, which empowers the court to set aside the arbitral award on limited ground enumerated can also be an appeal. So, this revision will not less than an appeal. Now, clause 33. Here from the exact clause 3 things comes. In Shankar Ramacharya Abhay Shankar versus Krishnaji Dattarai, the question was whether the High Court could interfere under Article 226 Constitution with the order of the appellate court in proceeding under the Act when a petition for revision under 115 of the Court. Again, the same order had been previously dismissed by the 11th single judge, the High Court. The following para from the judgment are opposite. It was error in In this is what happened. Clause 115 was tested, dismissed. Then 226 clause 5. Then in that context, what is the observation below says? It would appear that the Lordship of the Privy Council regarded the revisional jurisdiction to be a part and parcel of the appellate jurisdiction of the High Court. This is what was said in Nagendranath Day versus Suresh Chandra Day. There is no definition of appeal in the Civil Procedure Court, but the Lordship has no doubt that any application by a party to an appellate court asking it to set aside or revise a decision of the appellate court is an appeal within the ordinary acceptation of the term. Similarly, in Raja Ramanan versus Kami Rauthen, a civil revision petition was considered to be an appropriate form of appeal from the judgment in a suit of a small cause nature. A full bench of the Madras High Court in PPP so-and-so had to decide whether, with reference to Article 182 of the Limitation Act so-and-so, the term appeal was used in a restrictive sense so as to exclude revision petition and expression appellate court was to be confined to a court exercising appellate as opposed to revisional powers. After an exhaustive examination of the case law, including the decision of the Privy Council mentioned above, the full bench expressed the view that Article 182 applied to civil revisions as well, not only to appeals in the narrow sense of that term as used in the Civil Procedure Code. So, right of appeal was one of the entering a superior court and invoking its aid and interpretation to redress the error of the court below. Two things which were required to constitute appellate jurisdiction were the existence of relation of superior and inferior court and the power on the part of the former to review decision of the latter. In the well-known work of Historian Constitution of United States, Volume 2, Article 1761, it is stated that the essential criteria of appellate jurisdiction is that it revises and corrects the proceedings in a cause already instituted and does not create the cause. Kindly appreciate this. This is so much glaring and clear. This it states the essential criteria of appellate jurisdiction is that it revises and corrects the proceeding in a cause already instituted and does not create that cause. Then what they are asking for is, if in the revision they will come, they will same argument which was there in the appeal. The appellate jurisdiction may be exercised in a variety of forms, and indeed in any form in which the legislature may choose to prescribe. According to Article 1762, the most usual mode of exercising appellate jurisdiction, at least those which are most known in the United States, are by a writ of error, or by an appeal, or by some process of removal of suit from an inferior tribunal. An appeal is a process of civil law origin and removes a cause entirely subjecting the fact as well as the law to review and a retrial. A writ of error is a process of common law origin and it removes nothing for re-examination but the law. The former mode is usually adopted in case of equity and admiralty jurisdiction. The latter in suits are common law tried by the jury. Now when the aid of the High Court is invoked on revisional side, it is done because it is a superior court and it can interfere for the purpose of rectifying the error of the court below. Section 115 of the Civil Procedure plus specifically this provision considered there in section 115. Now when the aid of the High Court is invoked on the divisional side, it is done because it is a superior court and it can interfere for the purpose of rectifying the error of the court below. Section 115 of the Civil Procedure Code circumscribes the limit of that jurisdiction, but the jurisdiction which is being exercised is a part of the general appellate jurisdiction of the High Court as a superior court. It is only one of the mode of exercising power conferred by the execute. Basically and fundamentally, it is an appellate jurisdiction of the High Court which is being invoked and exercised in a wider and larger sense. We do not therefore consider that the principle of merger of order of the inferior court in those of superior court would be affected or would become inapplicable by making distinction between petition for revision and appeal. What more is required of us? Legislature could have was clearly said in section 13 itself, but there will be no bar to go in revision. Nothing as such. In abundant precaution, that what the legislature has also worded in section 8 also in a manner of being to restrict their export. Interrogatory order specifically mentioned, jurisdiction order specifically mentioned, any other challenge mentioned, and if not revision, then only section 13. And section 13 is restricted, and therefore the proxy says no, inapplicable by making a distinction between petition for revision and appeal. Then use paragraph 36 for vice transparency. That is also more clear. That will make the things clear. And then the judgment that my senior friend has just said is black diamond. I with great respect and distinguish that in the manner that has been read and that has been understood. My senior, I understood it just reverse, and that's place continues. On the perusal of the plethora of decision of the aforementioned, we have the view appeal is a term that carries a wide range of connotation, will fit, and that appellate jurisdiction can be exercised in a variety of forms. It is not necessary that exercise of appellate jurisdiction will always involve re-agitation of entire matrix of fact and law. We have already seen in our center that even an order passed by virtue of limited power of the revision under section 115 of the court is treated as an exercise of appellate jurisdiction. Though under that provision, the court cannot go into the question of fact, given the weight of authorities in favor of giving such a wide meaning to the term appeal. We are constrained to disagree with the contention and concept of the respondent corporation that appeal shall mean only a challenge with decree or order, where the entire matrix of law and fact can be re-agitated with respect to the impugned order or decree. There is no why that section 34 will say only limited ground of challenge to the what. However, we see no reason to why alone should be taken out and application under section 34 outside the ambit of the appeal, especially when even a power of revision is treated as an exercise of appellate given by this court will be imposed. Lord, kindly take the most broader most appreciation I am trying to say. Legislature is most conscious. Otherwise, there was the CPC already, civil courts were there. Then the commercial court, then the Arbitration Act also talks of Section 5 limited scope of interference by the judicial court. Then Section 34 talks of that against the intermediary refusal of Section 16 petition, etc. You have to wait till final award. Then Section 37 no second appeal. In spite of that, the things were being coming to the expectation of the legislature for next week. Then a special court this Commercial Court Act. Section 13 was so restrictive in my respectful submission that if having the things that anything which is not applicable will be revisable, then their whole purpose will be frustrated. And all the more when in this last paragraph 36 clearly says we have already seen in the Arrest Center that even order passed by virtue of limited power of revision under so and so treated as an exercise of appellate jurisdiction. So under that provision, the court cannot forget the question of fact, given the weight of authorities. All authorities, etc., is there lost, and such a wide interpretation lost in this two paragraphs are reading lost. Then if lost, we cannot say that the power exercised under this revision would be lesser than the lost power under the appeal. Section 13.
On the council, this is the last case. Mr. Rajiv Kumar, this is the last case, you may leave. Yes, this will go on.
So
This case will go on.
So by that part matter, that what is the date? Would you fix on what date?
Which one?
That first part matter. My friend is also here. 39.
It will come. It will be on the list. Yes.
Then when we claim, can we claim?
Yes, yes. Yes. Yes, Mr. Murari.
So I, with greatest respect and humility, I beg to submit that Section 13 of the Commercial Code Act should be interpreted in a restrictive sense and not in a wider sense. Otherwise, Section 13 will be rendered to ODOs as a whole. 227 cannot be equated to 115. 227 has got no relation with our argument clause. That is altogether different thing, different power, different jurisdiction. That cannot be circumscribed by any provision of law, any statutory mandate. Nothing can circumscribe this 227 laws. Therefore, we should not even think of laws in this context of the fact laws. That particular difference, if there is no 115 between 227, this can be all the argument that we can 115. If not, then people will start coming 227. We should not bother that. Because that has to be bothered by the honorable court, we will hear 227. And that will be taken care of by the arguments of the respective parties, whether 227 is entertained in the fact of the case or not. But there cannot be a reverse argument that if there is no 115, then everybody can go into 227. In my respectful submission, that argument is of no use in this case. We are confined and concerned with the scope of Commercial Code Act, the scope and ambit, objective of the Commercial Code Act, and Section 13 language, and then the interpretation of appeal word given by the Privy Council right from us and then the full bench of the Madras High Court. And so clearly, it has been said that only this is nothing less than the appellate power. If it is so, then this revision will fall within the scope of Section 13. This is one. So I will again say that the revision is not maintainable at all. It will circumvent the provision of Section 13. This is what I suppose. Now, the judgment that my senior friend has read, this black diamond judgment, I will take again the question very carefully. What is the question that has been framed? It has this judgment plus 2 days night earlier I downloaded. Now I was trying to read very slowly. Paragraph 6. 6. In this case, what has happened? Plus 2 cases. One case was under this ordinate rule 1 where the WS was rejected 120 days. And the provision in Commercial Code Act is that it is restrictive, it is strict provision, no controversy. Second one was Order 7 Rule 11, the rejection of claim. But actual argument was it was not in the nature of rejection of claim, rather it was Order 7 Rule 10 petition for the jurisdictional error. If it is not, then it will go to the other.
Return of
Return
to be filed before an applicant.
Now, what question was framed was exactly correct. What has happened was the matter went before the single judge. 227 petition was there, and single judge came to the finding that it is a commercial court provision, and for commercial court cases, and the commercial division is there, I will not hear it, go to the division bench commercial court. Now, upon that consideration, what has been framed was this. Whether after coming into force of the Commercial Code Act 2015, a petition under Article 227 of the Constitution of lies with respect to non-appellable order of the Commercial Code, the word is not interlocutory order. Here these two words non-appellable. Here they must catch words. Their lordship has framed a question. If the order is not appellable under the Commercial Code Act, then what will happen? 227 was filed. The argument was raised that no 115 is maintainable. The lordship ultimately came to the close finding that no, the order which is non-appellable.
It says, again reader, whether after coming into force of the Commercial Codes Act of 2015, a petition under Article 227 of the Constitution of India lies with respect to non-appellable orders of commercial. Non-appellable orders.
And like this.
How much? Whether like this or like that will come to later. What do you mean by non-appellable order? The order which are not specifically appellable in terms of a particular statute.
Section 13.
I'm not on section 13. Forget about section 13, section 11, all sections, all statute. Appeal is a creature of statute. This means an order which is non-appellable, that means an order which does not provide for filing an appeal, whether 227 is applicable or not.
With greater respect, Willows, non-appellable is suffixed by the order of the Commercial Code.
Forget about order of commercial code. Maybe it's an order under the Workers' Compensation Act.
Now, Willows, kindly, I will not.
I'm saying it's a non-appellable. The word non-appellable means what? Appeal which is not provided in the statute. That means what can be an order except which will not fall within the ambit of non-appellable order? What is the other side? That means when the court restricts that respect to non-appellable order, that means there must be some order which is appellable. Appellable means under the act which is appellable. What do you mean by non-appellable orders?
I respectfully mean, Willows, that the order which are do not fall within the order 43 of the CPC vis-a-vis Commercial Code Act, because it was the order of the commercial. Because this matter has been dealt in the context of the commercial dispute and by the Commercial Appellate Division of the High Court, and the order was passed by the Commercial Code, the respective, and the paragraph 2 and 3, if you also kindly take notice of this judgment, paragraph 2 and 3, the orders were passed by the Commercial Courts.
Yes.
And that would be at the level of the district judge, who is especially there in the Commercial Court. Therefore, laws, whether after coming into force of the Commercial Code Act, a petition under Article 220 of the Constitution of India lies with respect to non-appellable order of the Commercial Code. I respectfully submit laws.
Nowhere it says, nowhere the word interlocutory order has been used.
Gratefulness.
Nowhere the final order has been used.
Gratefulness.
A final order may not be applicable at all point of time.
Therefore, I am saying,
A final order may not be applicable also.
gratefulness. Therefore, what I beg to this laws,
Yes.
that the question is
It decides only with non-applicable orders. This first question is restricted only to non-applicable.
Therefore, was beside this question,
Yes.
what I will respectfully must I will take your lordship, paragraph 26.
26.
And after holding
Yes.
that these are revisable order under section 115, yet what was the question posed exactly at the last by the Honorable Court?
Yes.
Finally statements. In so many words, it has been held that these two orders are revisable under section 115. Then the actual crux comes at paragraph 25 and 26. Having held that order impugned in CMM number 132 is revisable under section 115 of the court, we inquired from the counsel for the petitioner then how a petition under Article 227 Constitution is maintainable. The lordship has intended, so why not go on revision under 115 instead of coming to the 227? The answer was yes, and then the argument. The counsel for the petitioner in CMM 132 so contended the petition under Article 220 Constitution of India has been filed because division under Section 115 is barred under the Commercial Code Act. So, understanding it was that though it is revisable in general law provision.
No, that is his contention.
The contention. Then was what is the ultimate finding was kindly I am coming to that. But I am just trying to understand this judgment and trying to explain it what it actually means. It is so fastly read that it was not as that it was read. What actually come. Now the petition under Article 227 of the Constitution of India, we have considered the express respect. The petition under Article 220 of the Constitution of India is a discretionary remedy on which discretion is ordinarily not exercised when an alternative remedy is available under the CPC. In Surya Deorai, there was all the judgments have been quoted. I will speak that it has been held that Article 227 cannot be invoked when the remedy of appeal or revision are available. Thus, the whole section 8 of the Commercial Code Act, the petition under Article 227 would not have been entertained as an order of dismissal of application under Order 7 obtained the CPC for the reason of the statutory remedy of division petition being available to the petitioner's defendants. The exercise by the High Court of the power to rescind 227 is subject to well-known, well-settled rule of self-discipline and its practice. Such jurisdiction power is not exercised in derogation of the statutory provision. In Qualidian versus Janki versus Rail Controllers also, it was held that it was not appropriate for the High Court to have interfered with the ordering exercise of power under 227 when the proceeding arose under a special act which did not provide for the second appeal or revision to the High Court. That the purpose behind not providing such remedy was to give finality to the order passed under the Act rules. Similar in Nayan Ahmad Khan Fenso, it was held that the power of superintendence under Article 227 cannot be exercised in a manner ignoring or violating the specific provision of the statute. That High Court, while purporting to exercise power under Article 227 to keep inferior court and tribunal within the limit of their authority, should not itself cross the limits. To the same effect, in Sunita Rani versus Swenso, reported in Swenso, A. Venkata Y. Naidu versus Swenso, it was held that though no hurdle could be put against the exercise of the constitutional power of the High Court, it was well recognized principle. Well, in judicial recognition, the High Court should direct the party to avail himself of this statutory remedy before resort to the constitutional remedy. The petition under 227 was held to
Mr. Counsel, just 1 minute. This particular matter which you are reading, this is CMM 132 of 2021. What was the impugned order of CMM 132?
You order was already one petition was rejected.
What was that?
Written statement.
Written statement was?
But
CMM, that was CMM where there?
it's paragraph 3.
Well, 132 is with respect to Order 7 to 11.
Paragraph
Rejection of claim.
paragraph 2. Same
What is CMM? Because what was that CMM 132?
Same is the nomenclature of the case.
No, CMM 132 was against which order?
Yes, and the order passed under order 7 to 11.
Page 2,
7 to 11.
like page 2, Order 7 to 11, rejection of claim. Rejection of claim.
Let me place it paragraph 2.
Read paragraph 2.
Paragraph
Read that.
CMM 132/21 was filed impugning the order dated 25th September 21, the District Judge Commercial South Delhi, Saket Court, New Delhi, Censure, of dismissal of the application of petitioner defendant under Order 7 to 11 of the Code of Civil Procedure. Said suit was filed by the respondent pending for permanent injunction to restrain the petitioners defendant from passing off their goods as the respondent plaintiff and from the relief. The petitioner's defendant applied for rejection of the claim in the said suit on the ground that court had Delhi not having territorial jurisdiction to entertain the suit and on the ground of relief claimed in the suit being part of the judicata. That includes judgment the same case was dismissed. Now, of course, this has been dealt with at paragraph, and it has been said that it would be read like the
No, what happened ultimately, what the court held, that it has jurisdiction.
it is rejected.
In CMM 132?
Yes, it had it held.
No, CMM 132 of 2021,
No.
the court, Delhi subordinate court, application was dismissed, means the application to reject the plaint was dismissed. Court held that the court had jurisdiction.
Court had jurisdiction.
The court had jurisdiction.
Now, I can see what was said. It was said to be the final order.
This civil revision, the court has imposed 227 because that civil revision 115 was specifically part 112(3). The division bench was discussing, when you are reading division there, it has to be read with in consonance with 12(3), not 8. 12(3).
It's what I read to your lordship.
3 plus section.
12(3) of the Commercial Courts Act.
Well,
That is a complete work. When the court holds that it has jurisdiction.
section 12(3). No appeal or revision. And
Do you get me what I am trying to say?
As the case may be alive from
I
the
apologize.
Commercial
That is what I
Division
faced.
Court found it has jurisdiction. Where the commercial
So in
district-
CMM 132, the court says that I have jurisdiction to hear this case. So when you are reading all these things, this is not section 8. The revision bench is not section 8. It is 12(3).
So my lord,
The revision is exclusively bar. So 227.
I'm obliged.
so is what I am saying. I have now understood this.
You understood?
So I was not at that place.
So it is not. It will not help you.
It will not help you.
Yes.
But what I am saying was that at one paragraph it has been said that Chinese universities that this is the final.
Now see. Now see. You come to this. You come to what you have just now read. Let me take you to this. While you held that the court has held that this is a revisable order.
Yes, sir.
Yes.
Mm-hmm.
23. Come to paragraph 23.
Thus it follows
Thus it follows that the court has CMM 32 is revisable under 150. Stop here. The division bench holds that it is revisable order. But the bar comes under 12(3).
12(3).
So no revision, go to 27.
Therefore, this judgment will not help you.
That will not help.
So I will not. I am grateful.
Now I have understood what you have. The other part. You have.
Other part. So I will leave it.
So now let us conclude.
Let us conclude. So was that part was I am saying was that I am still of the view that looking to this judgment and the interpretation of the appeal.
Yes, that I have gone to.
That
The Kandla export is now it has seen.
not Kanlamnas, this Snehaldip plus.
Yes.
Snehaldip
You have read it. It is with me.
Snehaldip plus
Maybe
structure.
it is with me.
So plus general provision will not be invoked plus 0 section 30 plus. It is always advisable plus to set this plus division because otherwise plus it will overreach the supplementary section plus 13 of the Commercial Code Act. Now plus the second question that whether it will be heard to the division bench or the single bench. Only one paragraph was this span healthcare. Here it was paragraph 12 has been quoted from the Law Commission.
Yes.
Page 4 bottom was. I may also allude to recommendation which led to the enactment of section 8 in the Act, with which this case concerned and are as follows. In view of the above, the summary of the key recommendations of the Law Commission are stated below. F. The Constitution of Commercial Division of the Commercial Court should take place simultaneously with the Constitution of the Commercial Appellate Division. The Commercial Appellate Division will hear the appeal against the order and decree passed by the Commercial Division and Commercial Courts. The Commercial Appellate Division do not entertain any civil revision or petitions against an interlocutory order of the Commercial Court, including an order on the
This is
issue
the
of
same which has been
jurisdiction.
quoted in paragraph 8. This is the same. This recommendation has been incorporated in paragraph 8
Paragraph 8 of this.
of the commercial code.
Section 8.
Sorry, section 8.
Section 8.
Section 8.
So what I am saying was that if this recommendation is to be read along with section 5 of the Commercial Code Act,
Yes.
it gives no doubt to us that it can be heard only by a court which has been conferred power by this act.
They appellate based in conferred power, appellate power.
That will be the omnibus commercial appellate division laws. That will just this section 5 constitution of commercial. Therefore, their lordship has used the word in the law commission report. The commercial appellate division will not have entertained word is used laws. Again, read laws. The constitution of commercial appeal division so and so. So take some so and so. The commercial appellate division to not entertain any civil division. Word is laws. Again, I read in laws. Come to this F that I have read just now. Scan case.
Yes.
Scan case. Paragraph 12.
Yes.
The word is the commercial appellate division to not entertain any civil division. So
No. Read full.
full rules, yes.
Any civil division application
The
or
constitution
petition
of-
against any interlocutory order.
Paragraph 8 of
The crux here is
bar
interlocutory order.
section 8 lordship.
I'm telling you, there are 3 or 4 types of orders. Interlocutory order, intermediary order, and the final order. So it bars interlocutory order.
Specifically, madam.
Paragraph 8 section 8 lordship.
Yes.
Bar against the revision application or petition against the interlocutory order.
Interlocutory order of a commercial.
Not withstanding anything contained in the law for the time being. No, I am on the second question.
Yes.
Who will it
Division bench.
Division
That I
bench.
get.
Division bench.
That
I am on the second.
That I
First
get.
question was I am
The intention of the legislature is such that it should go before the
Specially constituted court.
specially constituted court under the act.
under the act. Section 5 is so clear.
All challenge.
All challenge.
All challenge will go before the, this is your.
Because section 5 clearly says that conferred by the act, the Constitution of Commercial Appellate Division, after issuing notification under subsection 1, 3, order under subsection 4, Chief Justice of the concerned High Court shall by order constitute Commercial Appellate Division having one or more division for the purpose of exercising the jurisdiction and powers conferred on it by the act. Plus, second question is no more restricting grammars. It will go to the division bench if at all division, if at all. But still, I am just making the submission because that general law remedy in the nature of 115 may not be permitted to be invoked. Divorce Milos section 13 of the Commercial Code Act.
That you have already
To be read with Milos this interpretation of appeal of this Milos 2010 3 SCC 34 Milos.
334.
Otherwise, Milos, there will be no purpose of Milos section 13 at all. That will be frustrated Milos. And in general also, I am trying to understand a appeal which is to be heard by the Milos especially constituted Commercial Appellate Division. In a lay manner, I am trying to understand. Cannot consider the order, cannot entertain the order. Can it be entertained in Milos general or immediate under 115? It is not practicable also from the point of view. Therefore, so exhaustive interpretation of appeal has been given in this judgment, and it has been said, had it been there is no prohibitory clause under section 13, then this question could not happen. But since there is a proviso clause and there is a double proviso, not only one proviso, and proviso clause has got meaning to qualify the main provision.
That is there in the contract
export clause.
That will dealt in details.
So, sir, double rider is there clause paragraph section 13 and again raised for consideration slowly. Okay, there is a double rider clause, not single rider clause, only single. And reading clause 1A, any person aggrieved by the judgment or order of the commercial court at the level of the district judge exercising original civil jurisdiction, or as the case may be. Commercial division of the High Court may appeal to the Commercial Appellate Division of the High Court within a period of 60 days from the date of the judgment order, provided that an appeal shall lie from such an order passed by the Commercial Division of Commercial Court that are specifically enumerated under Order 43 of the Code of Civil Procedure as amended by this Act and Section 37 of so and so. notwithstanding anything containing any other law for the time is enforced. So there is a double rider. All these rider will dilute to loss. If 115 is interpreted in abstract and in isolation of this provision laws. And therefore, my respectful submission that irrespective of any quarrel regarding jurisdiction, etc., one can go into 27 laws. That is altogether a different thing. But again, at the cost of repetition, I am making my submission that even laws in Susdev case or laws latest this Radheshyam case law ultimately what precipitated that even after amendment in 115, though divisional jurisdiction is out, but nobody can be rebellious, the 227 is always available. So that is the purpose ultimately, because even 115 has been interpreted in that way, that with in the general law parlance, that taking away 115 will not take away 227. Therefore, I am submitting laws, section 13 to be read with section 8 and to be read with section 5 and to be read with this was
the other case is also on the same
Exactly the same issue.
The impute order is same.
Almost the same.
Impute order is common impute.
No.
And in the other case, the same parties are same.
Party
Lawyers.
Yes, yes.
Lawyers are same.
I have opinion.
My lord, my appearance has been given my name, Sunil Murata. My lords,
Yes.
may I please, my lords?
Yes.
My lord, according to me, the Commercial Courts Act is only an amendment to the CPC, which has been put in one place for ease of use with respect to commercial disputes. For ease of use. Why I am saying? Because commercial courts are civil courts. They will deal with only commercial disputes which has been defined under the section, definition section. And my lords, what is not defined here or what is not the meaning of the words and expressions which have not been given here, then we fall back to the CPC or the Evidence Act. What is not amended by the provisions of the Commercial Courts Act, we have to look back to CPC and fall back on CPC with regard to everything. So it is just an amendment to the certain provisions of CPC with respect to a class of cases. So the CPC provisions have not been ousted. No, nowhere it says. But only to the extent for what is provided for here and to the limited extent. My lords, will see section 3 subsection 2, section 2 subsection 2, that is the definition clause, the words and expressions, because my lords, here many of the things have not been defined. Definition clause, commercial appellate court, commercial appellate division, commercial court, commercial dispute, then commercial division, civil judge, document, notification, schedules and all that. At the last subsection 2, the words and expressions used are not defined in this act but defined in the CPC or the evidence shall have the same meaning respectively assigned to them in that code and in the act. So my lords, when we file a case before the commercial court, what is it? It is a claim. It is not described here, not defined here. It is defined in the CPC. A written statement, not defined here, defined in the CPC. So this is only for the ease of use, for the purposes of commercial courts, that you have put an act separately, but basically it is an amendment to the CPC. And the commercial courts are civil courts for all purposes. They have been just made as a separate class to deal with specific disputes and nothing more. And some changes in the procedures, what to be done, what not to be done, has been provided for in this act. Would my Lord see section 11? Very important. There's some problem with the mic, I believe. My lords can hear me, I believe.
Yes.
Section 11. Bar of jurisdiction of commercial courts and commercial divisions. Notwithstanding anything contained in this act, a commercial court or a commercial division shall not entertain or decide any suit, application, or proceedings relating to any commercial dispute in respect of which the jurisdiction of civil court is either expressly or impliedly barred under any other law for the time being in force. So, if there is a bar with respect to a civil court entertaining a petition, there is also a bar with respect to a commercial court entertaining the same petition. No, they can't entertain. That means, if there is no bar to an entertainment of a petition by a civil court, that will not bar the entertainment of that petition by the commercial court. Section 115 in this case.
You are referring to section 9.
Section 11.
Of the CPC.
Section 11 of the
Section 9.
CPC. Yes, ma'am. Courts to try all suits unless barred. So, section 11 says that the commercial court shall not have jurisdiction to entertain any suit, application, or proceedings relating to any commercial dispute in respect of which the jurisdiction of the civil court is either expressly or impliedly barred under any other law for the time in force. Let us take that, my lord, the CPC is any other law. This is a separate law. Let us take CPC is another law. Under 115 is a petition, a revision petition barred for a civil court. It is not barred. If that is not barred and not specifically barred under this act, then the commercial court can entertain a petition. Because all the other provisions of the unamended provisions of the CPC, which are amended by this Commercial Court Act, are applicable to the commercial courts. Unless there is an absolute bar.
You know, when you do legal interpretation,
And let me first complete my notes. I have something more to say.
Yes.
With respect to my note, with respect to the judgment cited by my learned friend notes,
Yes.
2010-3 SCC 34.
Yes.
One of the two paragraphs, just page 47, my lords.
Page
47 at the top. That
page 47.
Yes, my lords. That was starting at page 34.
No, I am this one.
I am talking about 2010-3 SCC 34.
10-3.
10-3. 2010-3 SCC.
10-3, 34.
At 47.
Is 47.
Top paragraph, that 6. Small paragraph 6, not 34. Just paragraph 6. But of the last 3 lines of this first paragraph, we do not, therefore, my notes have it. Paragraph 6, quoted from some other judgment.
Yes.
We do not, therefore, consider that the principle of merger of orders of inferior courts in those of the superior courts would be affected or would become inapplicable by making a distinction between a petition for review and an appeal. It's merger of orders. My lords, when an order of a inferior court is interfered by the appellate court or the revisional court or higher court, that order merges with the order of the appellate court or revisional court, the higher court, and is applicable subject to the modifications which has been made by the higher court. So it's a question of merger. We are talking about merger. Then my lords, paragraph 36. My lord, what happens is, what my friend is submitting is, appeal and revisional jurisdiction are both appeals.
This particular judgment was in respect of the Interest Act.
Was
Interest
it-
Act, residing law section 34 of the plus arbitration.
And my lords, I'll just make a submission on
Appeal
that.
and application was the word. The argument was that application under section 34 cannot contain the provision of the appeal under section 7 of the Interest Act.
Why, my lords, I'll tell that.
Yes.
Under the Arbitration Act, my lords, with respect to, if your lordship sees section 37. Sorry, just a minute.
Yes.
Section 36, Arbitration Act. My lords, have it, can you?
Yes.
Arbitration Act, section 36. Why that interpretation, my lords? That 34 would be an appeal, and you have to make a mandatory deposit of 75% of the awarded amount. Mother,
Yes.
so my lord, let me read paragraph 36 also of this judgment if your lordship has 2010 3 SEC. May I read that?
Read paragraph 40, the last 5 lines.
My lords,
Read paragraph 40, the last 5 lines.
40 of this judgment, my lords.
Paragraph 40 at page 49.
Yes, my lords. Last,
Last 5 or 6.
the meaning of this term.
Hence the rights.
Hence, the right context in which the meaning of the term appeal should be interpreted in is the Interest Act itself.
Read thereof.
The meaning of this term under the Arbitration Act or the Code of Civil Procedure would have been relevant if the Interest Act had made a reference to them.
Read thereof.
For this very reason, we also do not find it relevant that the Arbitration Act deals with applications and appeals in two different chapters.
Thereafter.
We are concerned with the meaning of the term appeal in the Interest Act and not in the Arbitration Act. So it is limited to consideration of the term appeal under the Interest Act and not under the Arbitration Act. Why, my lords? Would my lords kindly see section 36 of the Arbitration Act?
Yes.
What happens to an award if it remains unchallenged? Where the time for making an application, my lords have it? Section 36,
36.
enforcement.
Yes.
Where the time for making an application to set aside an arbitral award under section 34 has expired, then, subject to the provisions of section 2, such award shall be enforced in accordance with the provisions of the CPC in the same manner as if it were a decree of the court. So the award is taken to be a decree of the court and to be executed by a civil court. So if it is a decree, award is a decree, so any forum where you challenge that award has been treated to be an appeal under the interpretation of the Interest Act, where it says if you are preferring an appeal against that order or award, then pre-deposit of 75% of the awarded amount is compulsory. So to the limited extent of interpretation of the Interest Act, that interpretation has been made. Award has been treated to be a decree. Any challenge to the decree before another forum would be an appeal. So pre-deposit of 75%. Because the Arbitration Act doesn't say that it is an appeal. It says an application. 34 is an application. Section 34. Finals.
Section 34 order is appealable.
No, yes, appealable. Under 37.
Yes.
No, section, I know. Then that will be a second appeal. If we go by what has been said in interpreting the Interest Act, then that would be a second appeal. Because if 34 is taken to be a first appeal, and 75% deposit, then 37 would be in the sense of second appeal. Because it says 34 says application for setting aside an amount. It doesn't say an appeal. But in terms of the Interest Act, for the purpose of the Interest Act, they have said that this 34 would be treated as an appeal. So pre-deposit of 75% of the awarded amount is mandatory. So you cannot escape that. And my lords, as far as this appeal and revision is concerned, my lord, the CPC clearly defines what is an appeal under section 96 or 104. It defines what is a revision under 115. If they were one and the same, why would the legislature have put it in two different places and defined them and their jurisdiction in two different ways? And section 12.3, which I had pointed out to your lordship in the morning, that clearly says
That's,
I am deeply obliged by this.
yes, Mr. Murari.
One thing I had brought for my lord's consideration, grace on statute law, gives us two pointers. We just have a look. Two circumstances.
Just 5-page written notes of arguments.
Two circumstances in which
Notes of argument on this issue, on the preliminary issue. Not on the main merits. What is this? What are you showing this?
grace on statute law you are showing.
Take away rights.
That's one thing. You have to turn to page 122.
Yes.
To confer jurisdiction and to take away jurisdiction of a superior court, specific provisions required. There is no provision which says that a revision should go before a division bench or commercial appellate bench. There is no provision which says that honorable single judge cannot hear. Neither taking away of jurisdiction of your lordship nor conferment of jurisdiction upon the honorable division bench has been taken care of by legislature in specific courts.
Just a 5-page.
And blood revision under 115 was an available existing right. But what it says is this. Your lordship has noted in the first portion.
Yes, argue, please. Just a 5-page, not more than that.
My lord.
Mr.
On the two issues, no?
Only two issues.
One is appeal or revision and second is division
Whether
bench of
revision
single
is
judge.
maintainable or not appeal or revision. Whether revision is maintainable and whether before the division.
Yes, it is. Yes.
Only a revision.
Some time frame you not
As early as possible, judgment reserved.
Much obliged, my lord, for
Within
the
a week?
hearing.
Within a week.
Yes. My lord, I apologize. I got stuck. It was a part and matter.
He was there.
My senior friend, he came as a senior.
Yes.